Hearing in the appeal of Attorney General against Jonathan Reid and 3 others.
Yes, Mr. Casey.
May it please you, my lords, my lady, I appear with Ms. Kenra Muru, the appellant in this matter. My learned friends, Mr. Tom Poole, KC, and Emily Moore, appear for the 3rd and 4th respondents. As the board will have seen, in this case, the Court of Appeal dismissed the appeal from the judge's decision on procedural grounds and without reference to the merits of the appeal. It did so for reasons which we submit were plainly wrong, as set out in our grounds of appeal, which I'll turn to in a moment. The respondent's case also advances an argument that the appeal to the board ought to be dismissed. Notwithstanding any merit in our grounds of appeal to the board, it is said that the appeal is moot or academic, because in July 2021, the relevant funds, the putative proceeds of the fraud, were released to the respondents. And before the appellant could seek any urgent relief from the board to hold the ring pending this appeal, that had happened. Now, we say that too is wrong, and those facts alone don't render the appeal moot or academic, and I'll deal with that in due course too. If I may, I propose to first deal with our grounds 2 and 4. Which we develop in our case on page 973.
Oh, yes. Yep.
I think it's a convenient place to start because it also provides a brief factual introduction to some of the underlying issues, and also because if we're right on grounds 2 and 4, then that alone is dispositive of the appeal against the Court of Appeal's judgment. In summary, we say that the supposed point or argument that led the Court of Appeal to conclude that there had been material non-disclosure in the course of the application for the order formally joining CWI to the proceedings was obviously inconsequential and immaterial. And we say that there was thus no failure to comply with the duty of full and frank disclosure or of fair presentation upon the application to the Court of Appeal for an order formally joining CWI, which, although it was opposed by the other respondents, was technically ex parte vis-a-vis CWI. And the board would have seen, as it were, the chain of reasoning that led the Court of Appeal to ultimately to find that the joinder order should fall away because of material non-disclosure. Ergo, the Court of Appeal said the appeal was not properly constituted.
Why did they need to join CWI at all? What was the requirement?
Well, my lord, we say that the Court of Appeal erred in concluding that that did indeed have to be done, because the underlying events were, of course, that from a very early stage, CWI was a party to the application to the judge to discharge the MLAT restraint order. So that application was taken out by CWI and Mr. Smith and Mr. Adams, and they were obviously entitled to do that as persons affected by the order. And so, in fact, what happened was CWI issued that application perfectly correctly. The judge, for reasons which we say were also plainly wrong, discharged the order, and then we appealed the judge's decision. So we do say as well, that's our ground 5, that the Court of Appeal was simply wrong to hold that or to conclude that the appeal was somehow fatally misconstituted without some order formally joining CWI to the appeal, when the appeal was an appeal against a ruling given on CWI's own application. Mm.
And who should ordinarily be a respondent to an application such as this? The persons who are affected by the order can make an application to have it set aside, but who should ordinarily be the respondent to an application?
to an application for an MLAT restraint order,
Yes.
in ideal circumstances, no doubt one would name as a named respondent any account holder whose accounts one wants to have frozen. And if we look back at the originating summons seeking the MLAT restraint order, in this case, CWI's name wasn't in the title to the proceedings. We accept that. But the order that was prayed for and granted in terms said this order prohibits the following, and including CWI, from dealing with, in fact, either any funds in the two RBC accounts, which the US authorities had traced the money into, or indeed any other accounts held by or for the benefit of CWI. So although I think the point could fairly be taken that CWI's name ought to have been in the title to the proceedings as a named respondent, it was undoubtedly a party affected by the order, and within days of the making of the order had issued its application seeking the discharge of the order.
And the Court of Appeal also held there was non-disclosure to the judge in respect of the restraint order.
Well, my Lord, the Court of Appeal considered that there was, essentially for the same reasons.
Yes.
So our first point would be if those reasons are plainly bad, then as it were, they can't extend their reasoning further down. But we also say that it wasn't open to the Court of Appeal, sitting as the Court of Appeal, as it were, to decide that there had been material non-disclosure at the time of the application for the MLAT restraint order. That didn't form any basis of the discharge application that had been made by the respondents to the judge. And indeed, it didn't form any basis of the preliminary objections which the respondents had raised to the appeal, which the Court of Appeal was considering. We'll come to it, but the preliminary objections were precisely worded to allege that there had been material non-disclosure at the time that the appellant applied in the Court of Appeal to join CWI. And they were saying, therefore, that order should fall away, and therefore, as it were, the appeal shouldn't be allowed to proceed. And that was the reasoning that found favour with the Court of Appeal. But my Lord's right to point out the Court of Appeal said, if we're right about this, it must be the case that there was also material non-disclosure at that stage. So now, just in terms of making good our submission, that the point was obviously inconsequential and therefore didn't engage the duty of full and frank disclosure or fair presentation. As the board will have seen, the key aspects of the fraud that has been alleged by the US authorities are as follows. The fraudsters, seemingly operating from the Bahamas, incorporated a company in Georgia in the USA called CWI International Investments, which I'll refer to as CWI Georgia. And as we'll see, that company was incorporated on the 30th of January 2015. Then in October and November 2015, again seemingly operating from the Bahamas, the fraudsters persuaded Boeing that CWI Georgia was interested in purchasing a private jet. They somehow obtained details of a $2.2 million odd payment made by Fuji to Boeing, and persuaded Boeing that that payment was in fact paid as a deposit for CWI Georgia's putative purchase. Then on the 2nd of December 2015, a couple of days after that payment from Fuji had been received by Boeing, they wrote to Boeing purporting to give notice of cancellation of CWI Georgia's purchase and asking for the $2.2 million to be paid into an account that CWI Georgia had opened at SunTrust Bank in the USA, which is the SunTrust account that the board will have seen referred to in the papers.
SunTrust 1.
SunTrust 1, yes, which is really the crucial SunTrust account. I think the money seemed to have been moved between the SunTrust accounts for some reason, but I think we can focus simply on SunTrust 1. So I wonder if I could just firstly turn up that instruction. And if we go firstly to page 658, some email exchanges between this person using the name Jonathan Reid apparently at CWI Georgia and Boeing. And if one looks firstly at the email in the middle of the page from Michael Curtis at Boeing to Jonathan at CWI International. Dear Jonathan, while obviously the morning's news is disappointing, thanks for the update and we'll wait for the official notification via fax and email. And then give some information about possible sources for used BBJs. BBJ is a line of private jet produced by Boeing, and that's what CWI Georgia had claimed to be interested in. And then above that, you see the email from Jonathan Reid, dear Mr. Curtis, please see the attached. And then over the page at 659, one sees the instruction, which was, as it were, effecting the coup de grace of the fraud. So it's 2nd of December 2015, on CWI Georgia headed note paper, and one sees what it says. It serves as authorization and notice to cancel the relevant proposal. Please return the wire which was sent to the Boeing company in the amount of 2.2 odd million to the following. And then gives the details for a Sun Trust bank account, and one sees the account number given there, ending 3860. Now, that we see then was sent on the 2nd of December 2015, and we know that Boeing sanctioned that, because if we go over to page 661, the email occupying the bottom half of the page. This is a chain of emails where one sees Fuji writing to Boeing saying what's going on, and then some internal discussion at Boeing as to what's happening. And we see this is an email from Terry Trotner to someone called Yuko Gaitan, who I think is Fuji, and saying, Yuko, the funds were returned December 4, 2015, and then below is a screenshot from someone called Hilisha, who's at Boeing. And you see there's a screenshot's been taken of a printout of some banking details showing the amount, debit amount, 2.2 million, paid to SunTrust Bank Atlanta. And then across from accounting party, we see the relevant account number set out there, ending 3860. In the name of CWI International Investments Limited. Now, from there, again, I'll come to the document in a moment, but we know from the MLAT request that the bulk of the monies were then paid into one of CWI Bahamas Royal Bank of Canada accounts by means of 9 cheques between the 11th of December 2015 and the 7th of January 2016. And there were also a number of ATM and card transactions on the SunTrust account that took place in the Bahamas between the 4th of December 2015 and the 16th of January 2016. And the upshot was that when, in early January 2016, Boeing came to suspect that it had been defrauded and thought to get the monies back from SunTrust, they had already moved away. So can I then go to the MLAT request in order to identify the point that essentially formed the basis of the Court of Appeal's reasoning? The MLAT request itself starts at page 581. And the board will see from the first paragraph at page 581 that the Central Authority of the US was requesting the assistance of the appropriate authorities in the Bahamas. Then about halfway through it, they're conducting an investigation to determine the true identity of one or more individuals using the names Jonathan Reid and David Valdez Lopez, who executed the scheme that I've described. In the second paragraph, the US authorities have traced the process of the fraud to the RBC accounts held in the name of CWI Bahamas, and go on to summarise some information we'll come to. Then, just to look briefly at the foot of this page, the third paragraph, the US authorities are requesting the assistance of the appropriate authorities in the Bahamas to restrain all funds in the subject accounts in anticipation of US forfeiture proceedings, and also requesting business records from RBC and the Bahamas Telecommunications Company. I draw attention to the points about forfeiture in this document because it's said against us that at the hearing, at the ex parte hearing before the judge, when the MNAT restraint order was granted, there was not, in fact, material before her which engaged her power to grant an MNAT restraint order. And what these documents say about pending forfeiture is relevant to that. So one has the same point at the top of page 582. A reference in the second sentence to the danger that if the domestic restraint order falls away, as we know subsequently happened, then the funds could be dissipated and thus made unavailable for forfeiture in the US. The document then moves, after confidentiality, into the facts. And on page 582, I draw attention simply to footnote 2, showing that CWI Georgia and another entity that seems to have been involved appears to have been incorporated by online filings from the Bahamas. Then if I can pick it up, please, at page 583, paragraph 7. One sees there the reference in the MNAT request to SunTrust 1. At that stage, the documents were for some reason blanking out the first 4 numbers of the bank account, but we see that it's the same account with those ending digits 3860. And it explains that the named account holder for that account appears to be someone who'd been the victim of identity theft. And paragraph 8 gives the information that I've shown the board, that the payment was then made on the 4th of December by Boeing to SunTrust 1. Section B then, starting at the foot of page 583, gives some information about the emails and the IP addresses that were used in the course of the fraud, and concludes over on page 584, paragraph 12, that the IP addresses were provided by the Bahamas Telecommunications Company located in Nassau. Then coming to paragraph 13 at the foot of page 584, which is crucial for our purposes, records for SunTrust 1 show the SunTrust 1 account was opened on or about November 10th, 2015, along with 2 additional SunTrust accounts in the name of CWI Georgia. All the relevant SunTrust accounts were open online. Signatory was a person who's the apparent victim of identity theft, whose name also crops up in corporate records in relation to CWI Georgia. And then the final sentence over on page 585, all of the SunTrust accounts were closed on January 23, 2015. So obviously the first sentence of paragraph 13, saying the account was opened on November 10th, 2015, and the final sentence can't both be right. There must be a typo in one. And then paragraph 14, SunTrust records for all 3 accounts indicate large sums of money were wire transferred to, from, and between all 3 accounts. And then moves on to give the information about the checks that were used to move the bulk of the money from SunTrust 1 to the RBC accounts. And paragraph 15 records that SunTrust records show the following details, and you see there a table with the checks, dates of the deposits being between 11th of December 15 and 7th of January 2016. So that was how the vast majority of the proceeds of the fraud appear to have been moved into the Bahamas and into the RBC accounts. And then just taking it through to page 586, paragraph 18, also relevant for our purposes, transaction records for SunTrust 1 and SunTrust 3 show that between the 4th of December 2015 and 16th of January 2016, funds from these accounts were debited via ATM, cash withdrawals and debit credit card purchases, all occurring at various locations in the Bahamas, and then gives some details.
So all this information was also in Stirrup 1?
All of this information is also in Stirrup 1, which, as my Lord has seen, essentially replicated verbatim the MNAT request, including, therefore, the reference at the end of paragraph 13 to the SunTrust accounts having been closed on the 23rd of January 2015. And then just coming back again to another forfeiture reference in paragraph 19, explaining that on the 25th of April 2017, the Honourable James L. Robert, District Judge Court for the District Court for the Western District of Washington, issued a temporary restraining order for the RBC accounts and explains in the last couple of lines that that's been done as an initial step to forfeiture under US law, subject to the operation of the law of the Bahamas. It then goes on to give details of the offences suspected, which I don't think we need to look at. But if I can take you through to the temporary restraining order, which was exhibited to Stirrup 1, is at page 595. So one sees that it's entitled In Re Grand Jury Matter. And then the recitals say the matter comes before the court on an ex parte application for a temporary restraining order, seeking to restrain pending criminal indictment, all funds on the deposit in the following accounts, and then gives the details of the RBC accounts. And then going over to the top of page 596, the court, having reviewed the material referred to there, hereby finds probable cause to believe that some of the funds in the above identified accounts are process of wire fraud in violation of that particular provision of the United States Code, which is subject to forfeiture pursuant to these further provisions of the USC in the forthcoming prosecution, and probable cause to believe that delay required, etc., would jeopardise the availability of the funds for forfeiture. And then you see the operative part of the order that all funds on deposit in the above identified accounts are restrained, etc. Worth noting 5 and 6 of the foot of page 596. A return date, as it were, to be held or a further hearing, and then if prior to the scheduled hearing, the United States obtains an indictment that alleges forfeiture of funds in the above identified accounts, the United States shall promptly notify the court and seek post-indictment restraint of the funds pursuant to that particular provision of the USC. Now, all of this material was before the Court of Appeal at the time of the hearing of the notice of preliminary rejection. And we submit that looking at the material that was before the court, it erred in concluding that there was any real issue as to whether the 2015 reference at the end of paragraph 13 was a typo. In fact, we say the evidence showed beyond doubt that it was a typographical error, and the Court of Appeal essentially failed to take the evidence into account in concluding that there was any real issue.
Why do you say it's a typographical error as opposed to an error?
Or some form of error, yes, my lord. Yes, merely an error. Maybe a typing error, maybe some other type of error, but clearly erroneous. And as we'll see, essentially the Court of Appeal seems to have taken the view that it wasn't open to it or wasn't appropriate for it to look at the evidence that went to this issue. And it sort of looked at things in isolation and said, well, we have to look at paragraph 13 in isolation, and it's not a matter for us to decide which of these two dates might or might not be correct. And we submit that that was simply unwarranted and an incorrect approach, and the Court of Appeal closed its mind to the relevant evidence.
The whole application was based on the operation of this account.
Yes, absolutely. I mean, we do submit really that it's a bit mystifying, the approach that the Court of Appeal took, and that it's really clear beyond any sensible argument that there was a stray reference which was simply erroneous. Now, we set out the key evidential points that we say demonstrate clearly that this was a non-point, simply an error, in our case of paragraphs 40 to 43, starting at page 974.
Those are the records you've effectively shown us in the MLAT request and in Stirrup.
Largely, my lady, yes. So I wasn't proposing to go through them in detail again, but perhaps worth looking at our summary of the key points of paragraph 43 on page 975. There's a further point that I haven't shown the board, which was that, in fact, there was a document that showed that CWI was only incorporated on the 23rd of January, on the 30th of January 2015, sorry. So hadn't been incorporated by the 23rd of January 2015, that being the putative competing date for the not only the opening of the account, but the closing of the account. And then our point at 43B, that it's hardly to be supposed that the fraudsters, on the hypothesis being advanced, would have asked that the deposit be transferred back to an account which had been closed some 11 months earlier. Detailed evidence about the dealings on the SunTrust accounts in December 2015 and January 2016. There's a further point which I don't think we need to look up, but when Stirrup 3 came along, it exhibited another letter from the DOJ, which this time got the date, we would say, right. And so Stirrup 3 did the same thing, replicated verbatim the letter from the DOJ.
And when did Stirrup 3 come forward?
Stirrup 3, my lord, is at page 635, 4th of April 2018. So it's after, Stirrup 3 was not before the judge on the ex parte application for the eminent restraint order, but it was before the Court of Appeal when the Court of Appeal considered these issues. And perhaps I could just take you to the references so that you see them. Page 638. Roman subparagraph 12. In fact, a subparagraph of paragraph 6. UC says, towards the end of it, by the end of January 2016, the proceeds of the Boeing fraud had been moved from the SunTrust account of CWI, which is what they called CWI Georgia, to the RBC account of CWI Women, that is the Bahamian entity. SunTrust 3860 was closed on the 26th of January 2016. The account had existed for less than 3 months. And that was as I say, replicating part of the DOJ letter, which you see on page 645. Around the middle of the page. Could I look then at how the Court of Appeal dealt with this and what it said about the points to make good my submission that it took an erroneous approach? If we go into the Court of Appeal judgment starting on page 267, in paragraph 23, under the heading the non-disclosure issues.
Sorry, what page?
Sorry, my lady, page 267.
267. Is that not the judgment of the judge? Oh, no, it's not, sorry.
I haven't taken the board to the earlier paragraphs of the Court of Appeal ruling because they've become irrelevant for our purposes, and this is where the relevant passage commences. Paragraph 23. These allegations relate to what the third and fourth respondents submit and matters which were not disclosed to this court during the appellant's application to join the fourth respondent as a party to the appeal. These are as follows. And the relevant one for our purposes is little 2. So this is quoting from the notice of preliminary objections, which had recently been filed. And then the Court of Appeal come to that point at paragraph 28 over on page 268. And one sees that at paragraph 28, they say that it's this second allegation of non-disclosure relative to the date of the closure of the account, which has exercised our mind. Not an issue raised by the appellant during the application for joinder, and on the face of it has potentially serious ramifications. Mr. Serville, who was appearing for the appellant, contends that it's apparent that there was a typographical error on the date of the closure of the SunTrust Bank account, and that this only became apparent to the applicant when raised by the respondent in this preliminary rejection exercise. Further noted that additionally the point was not taken in the court below on behalf of the third respondent, presumably because it also only became apparent to the third and fourth respondents during the preliminary objection exercise. And then summarises one of Mr. Servile's submissions at paragraph 29 that there's, as it were, one incident in which the 23rd of January 2015 date crops up, when in fact the actual date of closure, as evidenced by numerous statements and exhibits among the relevant documents, as being January 2016. Concludes on the basis of the foregoing, it's apparent there was an error. In paragraph 30, makes the point that it said that the appellant unfortunately did not discover the error until after the application for joinder had been made. Then firstly, the question of whether it was an error is a matter for determination. But clearly it wasn't raised with the trial judge by either party. Now, just pausing there, of course the point hadn't been raised with the first instance judge by either party because there was no allegation raised by the respondents of material non-disclosure in this respect. Then if I can take it through to paragraph 32 on page 271. Having quoted principles from the Blue Planet case itself, quoting Bringsmat and Elkham, says, "It's with this background that I now consider this allegation of non-disclosure. Firstly, the appellant accepted there was non-disclosure, although counsel sought to couch it as a situation where the issue was overlooked." That's not a fair characterisation of what Mr. Serville said. He was very clearly saying, we don't accept there was any non-disclosure, although he certainly did accept that there was no reference to the January 2015 potential point during the hearing of the application to join CWI. It then said, however, having regard to the authorities, the most he could realistically be saying was that non-disclosure was innocent, but it was contained within the documents in the possession of the appellant, etc. Paragraph 33 says the second point is that the information not disclosed was material to the consideration of whether to grant the order of joinder. As noted above, if the data of closure of the account was not in error, it goes to the root of the appellant's case. Then 35, again, coming back to Mr. Serville's submission that when one looks at the documents as a whole, it's quite clear that the 23rd of January reference is erroneous, and that he had submitted that it was a typographical error or some sort of error in relation to the date of closure. In 36, this submission on its face appears to be reasonable. However, there are two concerns. Firstly, in order to determine that a typographical error occurred and to correct the same would require the input of the person who prepared the documents. Essentially, seemingly saying that the Court of Appeal couldn't reach a conclusion as to whether or not it was erroneous without having had some material to that effect from the US authorities. And then going over the page, over to page 272, and secondly, this issue is important as it was not raised before the trial judge.
Just before you get to that, the sentence, the affidavit of Ashley Stirrup does no more than provide her opinion. The records were referred to, weren't they?
They were indeed, yes. What the Court of Appeal appears to have been focusing on was, as it were, the pure narrative text of that particular part of the affidavit, and closing its mind to the surrounding documentary material, contemporaneous documentary material.
Mr. Casey, you say in your written case at paragraph 45E that the Court of Appeal appears to have accepted that it was unintentional. Where do we find that?
Well, my Lord, firstly from paragraph 32, where the Court of Appeal say in the middle of the paragraph, having regard to the authorities, the most he could realistically be saying was that the non-disclosure was innocent. And the Court of Appeal doesn't at that point, as it were, go on to say, but that's wrong. There's been some deliberate non-disclosure. And then, just skipping ahead for a moment, paragraph 39 on page 272.
Yes.
This says, paragraph 32, last sentence, information was contained within the documents which were in the possession of the appellant, and he would have been aware of the fact that he made a careful review of those documents. Presumably that would be equally true of the judge and the respondent.
Absolutely, my Lord, yes.
Where in 39?
My Lord, so in 39, the learned judge says, no doubt in my mind the appellant had a duty to disclose the issue, etc. This they did not do, exacerbated by the fact that it wasn't disclosed to the trial judge, and more fundamentally, no evidence disclosed to the court during the application of the restraint order. This is supported by the submission of Mr. Serville, that they only became aware of it during the hearing of the preliminary objection. So, as it were, the Court of Appeal doesn't seem to have been rejecting that explanation.
I see.
Seems to have been accepting it, but saying it doesn't help very much.
Thank you.
So, my lady, just for a moment taking it back to the top of page 272, in paragraph 36. In the second line, one sees the Court of Appeal asking, the query is whether it's appropriate for us to determine the accurate date, which could possibly determine the issues in dispute in the appeal, on a matter not raised in the court below. Further, the issue doesn't even appear as a ground of appeal, nor in a respondent's notice. Now, just pausing there, in our submission, the Court of Appeal is plainly going wrong here, and certainly so far as these appear to be points made as were against the appellant. Firstly, there should be no query as to whether it's appropriate for the Court of Appeal to determine on the material before it whether it can be satisfied that the date was plainly erroneous. The issue didn't appear as a ground of appeal. Well, correctly because it had formed no part of the application before the judge. And there was no respondent's notice, but if that's a point against anyone, that should be a point against the respondents, not the appellant. And then, having posed that query at paragraph 36, we see the Court of Appeal answering it at paragraph 41. No basis for this court to determine the issue as to which date is correct. That was an issue which should have been brought to the attention of the trial judge for her determination.
So what do you say the Court of Appeal should have done?
Well, my Lord, the Court of Appeal should have, as Mr. Serville had submitted, looked at the material that was before it, the highlights of which I've taken the board through today, and had it done so, it would, we say, clearly have concluded that that reference at the end of paragraph 13 of the MNAT request and the corresponding paragraph in Stirrup 1 was indeed erroneous, and that the evidence essentially overwhelmingly showed that Sun Trust 1 was extant between November 2015 and January 2016, as shown by, amongst other things, the fact that Boeing was able to transfer the 2.2 million into it on the 2nd of December 2015, and the 9 checks were able to come out of it after that and into January 2016. Had the Court of Appeal, as were, concluded that it was open to it to look at the evidence, then it would have concluded that there was a non-point here. The date was plainly wrong. Ergo, there was no material non-disclosure on the CWI joinder application and or no failure in the duty of fair presentation.
Thank you.
Now, it's fair to say.
Your case is clearly an error. Is it also your case that there was no obligation to bring that error to the attention of the court?
My Lord, it is. If the fact is that it's clearly an error, then in fact it can't be material. No doubt if the point had been seen by counsel making the application for the MNAT restraint order, she would have said, I should say that there's this reference, but it's plainly wrong, and as it were, there's nothing in that. I mean, no doubt that's what any of us would have done had one been making the application and spotted the point. But that doesn't mean, as it were, that there was, in fact, a failure of full and frank disclosure or fair presentation in not spotting the point and not doing that, when the evidential picture is so clear that the relevant date simply must be wrong.
If it had been spotted, was there an obligation to bring it to the attention of the courts?
Well, my Lord, in my submission, it wouldn't be an obligation, no. I mean, no doubt as a matter of practice, one would refer to it because that's how one would cautiously approach it. But in my submission, if it was sufficiently clear, as we say it is, that the point was a non-point, then there would not be an obligation to bring it to the attention of the court.
Unfortunately, experience as a judge indicates that typing mistakes or whether they're typing mistakes or careless slips, but one way or another, trivial errors in the documentation put before judges is common.
My Lord, absolutely.
There'd be no end to it if counsel were to spend the first hour of the hearing going through every... I mean, here, how many pages have we got? 1,700 pages.
Yes.
If we're going to go through every mistake, we'll be here some time.
Oh, my Lord, quite. And no doubt my own case has got a number of errors, typographical and otherwise, and the same for my learned friends, and that's just the nature of the process.
We find our, as you no doubt find when you get our draft judgments.
Yes.
Our draft judgments.
My Lord, that's right. Of course, there could be a spectrum of cases. One can envisage hypothetical cases in which a standalone witness statement, and there's no contemporaneous material that can be used to inform the question, contains two competing dates, and there's no way of knowing which is right, etc. Then obviously that can be different.
Yeah.
But this wasn't such a case. I should just show the board what happened when Mr. Serville came at the hearing to try to deal with this point, because it's right to say that the Court of Appeal wasn't taken in detail through the documents that I've taken the board to. But as we'll see, that's because he was essentially told to make his submissions on this point extremely brief. And we can pick that up in the transcript at page 543. This is in the transcript of the hearing of the notice of preliminary objections on the 3rd of May 2021, and at line 8. One sees Mr. Serville saying, "The only other thing, my lords, is my learned friend had raised the issue about us having not disclosed material facts." And he's asked by Justice of Appeal Evans, "How much time do you need to deal with it?" He says, "I don't think very long." And then at line 19, "Make it 5 minutes, Mr. Serville, because I'm having a headache, so you need to press on quickly." And in the following pages, then, one sees Mr. Serville going on and dealing with it accordingly. He does say, at, for example, pages 545 to 546, referring to Stirrup 3, I think, and as was the expression of the correct date. And again in 546, lines 5 to 10, referring in a compendious way to the evidence showing activity on the account between December 15 and January 16, so being demonstrative that the point was an error. Now, my lords, my lady, those really are our submissions on our grounds 2 and 4, which we've, in fact, have rolled together for the purposes of these oral submissions. Our ground 3 is a standalone ground that the Court of Appeal erred in concluding that it wasn't open to it to make a determination as to whether the reference at the end of paragraph 13 of the MLAT request was a mere typographical error. And we say it thus closed its mind to and failed to take into account the evidence referred to under ground 2. And I think I've already been through that in the course of those submissions. We say that was clearly an erroneous and unwarranted approach. So if we're right about that, then we say that's the end of the matter because there was no breach of the duty of full and frank disclosure or a fair presentation. As the board knows, though, we do also, by our ground 1, say that the Court of Appeal erred in principle in taking the approach that it did to the non-disclosure that it considered had taken place, because it didn't consider the public interest inherent in restraint order cases. I don't propose to go back to the Court of Appeal judgment, but the board saw the approach that the Court of Appeal took, and it's really very much Brinksmat and Ilcombe and so on. This is where the principles are to be found. No reference whatsoever to the public interest aspect of the case. We do say separately that the Court of Appeal erred in going as far as it did even on the non-disclosure that it found, because, as I say, it seems to have considered it was innocent, yet nevertheless felt that it had no option but to discharge the CWI joinder application, which we say was also wrong. But on the main point, our ground 1, we accept that when, in this case, the Attorney General applies without notice for a restraint order, the Attorney General comes under the conventional duty of full and frank disclosure that applies generally to without notice applications. and we accept that a breach of that duty engages a discretion to discharge the order. But we say that in restraint order cases, including in a mutual legal assistance context, the fact that the applicant acts in the public interest militates against a discharge if there has been non-disclosure, and that essentially, although the discretion is unfettered, in such cases where there has been a material non-disclosure, the order should generally only be discharged if that is what the public interest requires. We don't say this is a rule of law, but the fact is that in this arena there's a public interest element involved, which isn't involved in normal civil commercial freezing order cases. Now, the board will have seen that in that respect we rely, as an accurate exposition of the principles, upon Jennings and the CPS. And if I could briefly turn up that authority, which should be at page 1459. In summary, in this case, Mr. Jennings was alleged to have been involved in a conspiracy inviting members of the public to pay £70 application fees for the making of unsecured loans, but it was said that no loans were made as from a certain point in time, and the funds were misappropriated. The CPS obtained a restraint order ex parte, and Mr. Jennings argued that it had, when applying for that order, made material non-disclosure of documents going to risk of dissipation and going to what Mr. Jennings' receipts from the alleged conspiracy could have been. The Court of Appeal accepted that there had been a material failure of disclosure by the CPS, and one sees that at page 1467, letter H. And then, if I can start with the judgment of Lord Justice Longmore, starting at page 1476. Lord Justice Longmore sets out in paragraph 60 the questions of principle that Lord Justice Clark had said were raised by the case when granting permission to appeal. First, what's the duty of the applicant in a restraint order case to set out reasons for fearing a risk of dissipation? Second, what's the correct approach of the court when the applicant fails to discharge that duty? Thirdly, does the applicant owe a duty to make full and frank disclosure of all relevant facts to the court? And then four, if so, what's the correct approach of the court to any failure to discharge that duty? In particular, are the principles the same as or different from those applied in the case of such a failure in a civil case? And we don't need to look, I think, at questions 5 and 6. We see then, at the foot of paragraph 60, Lord Justice Longmore agrees with Lord Justice Law's disposition of the appeal, which we'll look at in a moment. 61 says that essentially there has to be a fear of dissipation of assets for a restraint order to be made. And then around the middle of that paragraph, as Lord Justice Laws had said, in a case of dishonesty, the risk of dissipation will generally speak for itself. And then, page 1477, little 2, if there's a duty on the prosecutor to inform the court why, on the facts of a particular case, there's fear of dissipation, and the prosecutor fails to discharge that duty, it would be a strong thing to discharge the order altogether. If an application is made by a defendant to discharge on the grounds of no risk of dissipation, then the court can decide that on the evidence. If the court considers the prosecutor failed to consider whether there was a risk of dissipation, when he should have done, or failed to put relevant material before the court, but that the public interest still requires an order, the judge can deprive the prosecution of their costs, as in fact happened in this case. If the public interest requires that an order should be made, an order should still be made. And then 3, the duty to make full and frank disclosure applies to restraint order applicants as much as applicants for freezing orders. And 4, failure to discharge that duty, see the answer to above. The fact that the Crown acts in the public interest does militate against the sanction of discharge if, after consideration of all the evidence, the court thinks an order is appropriate. Not to say there could never be a case where the Crown's failure might be so appalling that the ultimate sanction of discharge would be satisfied. Now, if I can then go back briefly to the judgment of Lord Justice Laws, and picking it up at paragraph 54.
Page.
Sorry, page 1475.
Thank you.
Lord Justice Laws says, given the depth of argument devoted to this issue, the issue being what should be the effect of non-disclosure, is the little subheading on the previous page. Not right simply to leave the matter there. First, I should say that I concur in Lord Justice Longlaw's answers to Lord Justice Clark's questions and make some brief remarks about the proper response of the court to non-disclosure by the Crown in cases of this kind. And if I could invite the board just to read down to the foot of that page. We respectfully agree with the analysis of Lord Justice Laws that in restraint order cases there is this public interest factor which exists, which it's fair to say can pull in both directions. But nonetheless, we say that it's clear that when the court is considering whether or not a restraint order should be discharged, really one of the primary factors that must be taken into account is what does the public interest require. And of course there could be cases in which the Crown has acted so badly that the public interest requires the order to be discharged even if it's otherwise appropriate. But equally in cases where it can't be said that the Crown has acted so badly, then the public interest, if the order is otherwise appropriate, will generally require that it should be maintained. Now,
was the Court of Appeal referred to?
My Lord, it wasn't. It wasn't, which is obviously unfortunate. And the point is taken against me, I think, well, we shouldn't then be permitted to run this argument before the board. What we say as to that is this, that Jennings doesn't lay down some rule of law, which we're taking here for the first time. Jennings lucidly explains something which we submit really was apparent to the Court of Appeal anyway, namely that in this case the Attorney General was not acting as a sort of personal, commercial, private, civil litigant, and it's only private interests at stake. And so it is still fair to say that the Court of Appeal erred in its approach in not considering the public interest. And the point is important because at the moment as it stands, the judgment of the Court of Appeal may be taken as authority in the Bahamas that in cases concerning discharge of restraint orders, you take the approach of Brink's-Matt and Elcombe, and that's that. So although we obviously accept that it's unfortunate that the Court of Appeal wasn't showing Jennings, nonetheless, we're not now taking a point of law which we shouldn't be permitted to take, and it would plainly be salutary for the board to set the record straight in relation to the approach to be taken in the Bahamas in such cases in the future. The only other authority I was going to take the board to on this topic is the judgment of Lord Justice Hughes, as he then was in Director of the SFO, against A, which starts, I think, at page 1333. This was an English case in which the court had granted an order pursuant to an MLAT request. And the only point I was going to draw to the board's attention is what's said by Lord Justice Hughes at paragraph 3 on page 1334. Which is that, just to make good the contention, that even in an MLAT case, where one's not dealing with an actual or potential domestic prosecution, where the application is made on behalf of the English police or prosecuting authorities, the English public interest in any potential English order not being frustrated is plain to see. Where the application for a restraint order comes from a foreign country, there's still a legitimate English public interest in foreigners not being able to use this country as a place in which to shelter ill-gotten gains or their proceeds. And we do submit that resonates in this case when there is material to suggest that the fraud was carried out from the Bahamas, and that as soon as the fraud was successfully executed, the funds were moved quickly back to the Bahamas. And so we submit there's a very clear Bahamian public interest in not being seen as a safe haven for the commission of, or for the sheltering of the proceeds of, fraud.
He cites Jennings and relies on it.
My Lord, he does, yes. My Lord, our ground 5 was that the Court of Appeal erred in thinking that if the joinder of CWI was necessary, and that if the order joining CWI fell away, then that meant that the appeal was somehow doomed to failure as being procedurally improperly constituted. And I think essentially I've covered that ground. We submit that too was plainly wrong. The board will have seen that our ground 6 says that the Court of Appeal further erred because the appeal from the judge's order had merit, and therefore what the Court of Appeal ended up doing was dismissing an apparently meritorious, reasonably arguable appeal without reference to the merits. We do say in our case that we as it were, invite the board to conclude that the judge's decision was so clearly wrong that the appeal from her decision can be allowed here. I think with hindsight that was probably overreaching, and I don't, as it is, suggest that the board should, as it were, entertain a leapfrog appeal from the judge when the Court of Appeal hasn't yet adjudicated on the merits of the appeal. But we do say, for the reasons we've spelt out in our ground 6, that the judge's decision too is plainly wrong. I understand it to be said against me that the appeal from the judge's decision was devoid of merit, and what I intend to do, subject to the board's directions to the contrary, is wait to see how my learned friend develops that point, and then come back to it in reply as necessary. Can I then deal with the point taken in the respondent's case that the appeal shouldn't be considered by the board at all because it's been rendered academic. And if we can see how it's put in the respondent's case at page 987. At paragraphs 4 and 5. Now, in fact, what had happened briefly was that after the judge's decision, the monies were moved out of the RBC accounts into the respondent's attorney's client account of Monique Gomez and Co. On the 18th of December 2019, Sir Michael Barnett in the Court of Appeal granted an injunction restraining any dealings with the funds now held in that client account. That order was eventually extended so as to run until the appeal had been finally disposed of. Now, following the Court of Appeal's decision on the notice of preliminary objections, the appellant issued a notice of motion seeking leave to appeal to the Privy Council on the 16th of June 2021. And on the 22nd of June 2021, issued a summons for a further order restraining the funds as held by Monique Gomez and Co. Without trying to unpick the entire chronology, there was that summons was heard on the 24th of June and then again on the 1st of July. On the 1st of July 2021, Mr. Gomez confirmed that the funds remained in the account, and that application for an injunction was further adjourned. And on the 19th of July 2021, the Court of Appeal said essentially, well, it's all tied up with the merits of your potential application to the Privy Council for leave. We think you've got no merits, and so in the event, the application for that injunction was not pursued. The appellant then began to look at making an urgent application to the Privy Council for an order holding the ring pending this appeal. But a couple of days after the 19th of July, learned that the funds had left the account of Monique Gomez and Co. Now,
Is this explained somewhere?
my lord, it is. It's explained, in part at least, in our application for permission to appeal at 312 and 313. And it's also dealt with in the respondent's notice of objection at 331.
You required permission to appeal, did you? Obviously, there was a lot of money at stake here, but...
Well, my lord, there is. We said to the Court of Appeal that we were entitled to leave to appeal as of right, because it's a civil case, a lot of money at stake, and although it's an unusual civil case, it's a civil case, and the Court of Appeal disagreed with that analysis. And so we applied to the board saying, well, we're entitled as of right, and if not, we're entitled as a matter of discretion. My lord, the relevant
So that injunction application wasn't pursued as a consequence of you discovering that the money had
My lady, that's
moved
right.
out of the Gomez.
That's right. Although we don't accept that the appeal has been rendered academic by reason of the monies leaving Monique Gomez and Co., the view was taken that we couldn't make out a case to the Privy Council of sufficient urgency for an urgent application to the board for an order, with the monies now having found their way back or found their way into the hands of the respondents. My Lord Hamblin, I think that
And it said in paragraph 27 on page 313.
Yes.
The reason given for not giving you an injunction was that there was no need for the funds to remain restrained, as the appellant could trace the funds if it later succeeded in its appeal. The Privy Council.
My lord, that's right. We see that. I can show you that reference. It's in the additional bundle, which has been submitted recently. And
Sorry, page.
Page 12 of the additional bundle, but picking it up there.
Thank you.
And around line 10, we see the submissions of Mr. Higgins for the appellant commencing. This is the hearing this is the hearing which led to the summons for the further injunction. And Mr. Higgins is explaining that between lines 10 and 21, that if the funds are dissipated and the appellant is then successful in obtaining leave to appeal, then that would make it nugatory. And he's asked, why would it be nugatory? He says, because the process surrounds the restraint of the funds. And then Justice of Appeal Isaac says at line 25, yes, but if you're successful in your appeal, whoever has dissipated the funds would be responsible for restoring the status quo. Yes, and Mr. Higgins said that's a more difficult route. And then Justice of Appeal Evans says it's the proper legal route, though, isn't it? The whole thing is about tracing. Which we submit was again an erroneous approach. Although something akin to tracing may now be necessary, in the sense of obtaining further information, the appellant doesn't have any proprietary interest in the monies and doesn't have the ability to go tracing them in any conventional sense. But the Court of Appeal certainly seems to have taken the view in the course of that argument that there was no need for any injunction holding the ring and preserving the funds pro tem, because if it turns out that the appellant is right, then the appellant can restore the position in this way. But as I say, we do accept, and it's common ground, that the funds left the account of Monique Gomez and Co. at some point in that, seems in that July 2021 period.
Is the Court of Appeal suggesting that Monique Gomez would be responsible for restoring the status quo in that first line at the top of page 13?
My lady, possibly. No doubt that might depend on whether it could be said that she had done, that firm had done something wrong in releasing the funds. And the Court of Appeal, I should say at this time, was making it very clear to the appellant that the Court of Appeal thought there was no basis for insisting that the funds remain in the Monique Gomez and Co. account, and that the appellant, in fact, I think I'm right in saying the appellant was told to write a letter to the relevant bank saying, look, there is now no longer any block on these funds. That was the reference to a letter at the top of page 12 of that transcript we looked at. But can I turn then to my brief reasons as to why we say this is not a good point at this stage from the respondents? Firstly, we submit this isn't a point that the respondents can take unless they also explain what they've done with the funds. Although they're now no longer in the Monique Gomez and Co. account, if they're not beyond the reach of the Bahamian courts, then the appeal will not be moot. If they're in the Bahamas but have been transferred to other entities or have been used in whole or in part to acquire some other asset in the Bahamas, whether in the name of other entities or otherwise, then the appeal will not be moot. For the appeal to be moot in this sense, it would have to be the case that the respondents had successfully dissipated the funds such as to place them beyond the reach of any order of the Bahamian courts. Now, if they were to say that, they would need to put in evidence explaining when they got the money and what they've done with it afterwards and why it's now beyond the reach of the Bahamian courts. But unless and until they do that, in my submission, they simply can't say that the appeal is moot in this sense. It's not enough for them to say, essentially, sub silentio, it is possible that we've dissipated. They would have to be able to show that they've successfully done so. And if it turns out that the funds remain in the Bahamas, but obviously in some other bank account or been converted into some other asset, then if we succeed in the Court of Appeal, if the matter is remitted to the Court of Appeal, then the restraint order can simply be varied to cater for that change in circumstances, and the restraint order will be back in full effect.
The court does sometimes also hear appeals, even if the events have occurred which deprive the appeal of immediate practical consequences, wherever there is a need for the clarification of the law.
My Lord, yes, and we submit this is very much such a case. Particularly given the Jennings point and the fact that the Court of Appeal judgment might set matters off on a wrong footing for the future in the Bahamas if not corrected. And indeed the point that the Court of Appeal appears to have made an unjustified finding of material non-disclosure, which itself is unfortunate and should be set right if it's clearly wrong. Now, that's really what I proposed to say at this stage about the argument that the appeal is moot. Again, I'll return to it in my reply if needs be. I'm conscious that I haven't taken my full allotted time.
You don't need to apologise for that.
But those were the submissions I had, unless the board had any questions for me.
Thank you very much, Mr. Casey. Mr. Paul.
My Lords, my Lady, I'm grateful. If you just allow me 1 minute to rearrange.
Yes, of course.
Myself. My Lords, my Lady, I can summarise the respondent's case by way of 4 overarching submissions. First, reinstating the restraint order, we say, would serve no practical or useful purpose for the reasons you've just been hearing from my learned friend. The funds were withdrawn in July 2021 because they were no longer restrained. In short, we say, on the face of the evidence, there's no realisable property to restrain. Even if, and I hear my Lord Reid's point, that even if the issue raised on appeal is academic, there are obviously appeals where the board might nevertheless be minded to adjudicate on an appeal if it's in the public interest to do so. The only ground in my submission that could be said to raise a point of principle is ground 1. That leads to my second overarching submission, which is that ground 1 raises an entirely new point of law that was not raised below, as is set out in the case of Baker and the Queen, which we provided a copy to the board on Thursday.
Well, I have some sympathy with counsel for the who appeared below when he's told he's got 5 minutes and the judge has a headache, so get on with it.
My Lord, I too have sympathy with that, but the point is, it was never any part of either party's case, appellant or respondent below, that anything other than conventional, if I can call them those freezing order principles, should apply. So it's not as though he came armed with Jennings and SFO and A and was ready to deploy the argument. Had he been given all the time in the world, this point would not have been taken. And we do say that applying the principles that Lord Diplock set out in Baker and the Queen, this is not an appropriate case to depart from the board's usual practice, which is not to entertain points that were not raised below. And that is the only point of principle or general wider application.
Is there not a point of principle in relation to the non-disclosure point in the way the Court of Appeal approached it?
My lady, in my submission, no. Even if we're looking at conventional civil litigation freezing order applications, Brinksmat and Elcombe principles, we say that the Court of Appeal applied those principles in the manner that it was entitled to and reached a conclusion that it was entitled to. So there's no sort of wider point of general application or importance.
Mr. Poole, if we were to take the view that the Court of Appeal had actually applied the wrong test, then surely it would be open to this court to apply the correct test.
My Lord, I mean, that is really to circumvent what is said in Baker and the Queen, because if effectively the Court of Appeal applied the wrong test because they weren't taken to the correct test, or the authorities that set out arguably a different approach for restraint order applications, then I accept that is unsatisfactory, but that is a point that should be taken below. And if it is a point that should have been taken below, then what Lord Diplock says is that only in exceptional cases would it be right for the board to entertain it. And for reasons that I will develop, albeit shortly, we say this is not one of those exceptional cases.
Did the Court of Appeal really need to be taken to Jennings in order to realise that there was a public interest in play?
Well, my Lord, one of my answers to ground one is that even if there are different principles that need to be applied in the public interest, I think my learned friend puts it in his case that the public interest is the touchstone. And there's not a huge amount between my learned friend and I on this. I think it's really a point of emphasis rather than a point of principle. We say it's not. It was
clearly an error not to take into account the public interest in this case.
Well, Lord, we say that the Court of Appeal plainly would have had in mind the public interest in making restraint orders and the rationale behind, as we're calling it, modified POCA. And although I can't point in the Court of Appeal judgment to an express reference to that public interest.
They didn't need to be referred to Jennings in order to take into account public interest.
If that's as it were, my fallback argument on ground one. I take the point of principle, which is it's a new point. If, though, the board is going to entertain it, my answer to ground one in very short submission is it would have been plainly obvious the public interest behind making a restraint order. The Court of Appeal would have had that in mind, and they would have borne that in mind when applying the principles to this case. My third overarching submission, we say that the Court of Appeal was entitled to exercise its discretion in the way that it did, effectively to refuse to reinstate the restraint order. Again, just to summarise submissions I'll then expand on. We accept there was evidence before the Court of Appeal to suggest that the January 2015 date, as set out in paragraph 13 of Stirrup 1, was an error. But we say the onus was on the appellant as an applicant for a draconian order such as a restraint order to adduce evidence confirming it was an error. And again, we accept that on the totality of the evidence, which Learned Friend has taken the board through in much more detail than the Court of Appeal was taken through. Effectively, the Court of Appeal was referred to the reference in Stirrup 5 that said closing date of the Sun Trust 1 account was January 2016.
What better evidence could there be of it being an error than documentary evidence showing the movements on the account?
My Lord, there was no such documentary evidence showing say, for example, if there had been a bank statement of the Sun Trust 1 account showing activity between the period, I think, November 2015 and January 2016, I think I would agree with your lordship. The best, I think, Miller and Friend can point to now, again, not a document taken to the Court of Appeal were taken to, I think is really that email that you had from Boeing, which is page 661, which seems to show activity, or at least a transaction going to the SunTrust 1 account
On that date.
On that date. But a point we do take is we had some bank statements from the RBC accounts. They were in evidence. They didn't assist on this point because only one of those, and I'll take your lordships and my ladyship to this in a moment, there was a reference to SunTrust as a descriptor on one of the transactions into those RBC accounts, but again, it didn't link to the SunTrust 1 account. So this isn't a case where there was clear documentary evidence showing that January 2015 was an error in my submission. But again, the Court of Appeal accept that this was easily remediable, and they make this point in the application for conditional leave, and simply, I think they would say, onus was on the appellant. The appellant didn't put in evidence to show that this was clearly an error, as they should have done, and that's the point we take on this.
Well, the evidence is somebody has put in a statement saying it was a mistake. Or
Well, either you have a letter from the DOJ that says it's been brought to my attention that I said January 2015 when I clearly meant January 2016, and then that is a single line in Stirrup, what would have been effectively Stirrup probably 9 by the time we get there, given the number of affidavits that were put in before the judge. But we do say the onus is on in a restraint order case like this, the onus is on the appellant.
But counsel's submissions made clear that it was an error and that they only became aware of the error when it was
brought to their attention by the respondent on the notice of objection. Absolutely,
and
my
the
lady.
Court of Appeal doesn't seem to reject that.
Well, the Court of Appeal says, again, it was easily resolvable, are the words that the Court of Appeal...
But they required it to be resolved by the actual person signifying that it was an error. And there's no such requirement. The paragraph 36 at page 271. The author of the document must be the person to signify which is the accurate date.
My Lord, I mean, that could be taken to effectively be Ashley Stirrup in the affidavit. So in other words, we need affidavit evidence to show that this was an error, or it could, as I think your Lordship is indicating, it could be the DAJ. But either, I say, would be sufficient. What the Court of Appeal felt was insufficient, and in my submission, they're entirely right to make this finding, is that it's not good enough for counsel to just say this was an error when the point had been brought to the appellant's attention a good 7 weeks before the hearing, and it could have, again, I go back to the words of the Court of Appeal, been easily resolved.
They characterised what had happened as non-disclosure. Can you help me as to what it was that had not been disclosed?
My Lord, I mean, the way I would put it is it's really the duty of fair presentation is engaged, because it's really the duty of fair presentation, because it's really that there was an argument available to the respondents that on the face of the document, 2 different dates had been given for the closure of the SunTrust 1 account, and only one of those could obviously be right. And that was an argument that was available to the respondents to take. And so I say the duty of fair presentation is engaged, and it was incumbent upon the appellant to bring that to the judge's attention.
Which judge?
The judge determining the... so obviously you've got the ex parte application,
Yes.
first of all.
But are you saying it was an argument that should have been brought to the attention of the Court of Appeal? Because it's only in the joinder application.
Well, my lady, I'm working backwards. I say that obviously they don't appreciate the mistake until it's brought to their attention. But I say, like the Court of Appeal do, had they looked at the documents properly, they ought to have appreciated the inconsistency and that there was an argument available. So I do say the duty of fair presentation is engaged.
So what's the argument available? That
on the face
an account had been closed before it was even opened, and at a time when money was paid to the account holder, which hadn't then been incorporated. Is that the argument?
Well, I think the company that hadn't been incorporated was CWI Georgia, so not
That was the recipient.
not the fourth respondent here, but
No,
yes,
That's the recipient of the funds that were transferred.
yes.
Yes. So that recipient hadn't been incorporated on one of the dates.
On the documents before the Court of Appeal, that's right.
And that's the argument that was available to the respondents.
That on the face of the documents, given going back to the point I've just made about there being no bank statements from showing the SunTrust 1 account, there was an argument available that there were 2 dates given for the closure of the account. And it's not just the year, for what it's worth. So it's not just a case that 2015 is said when it should be 2016. I think when you get to Stirrup 3, the date is given as the 26th of January 2016, as opposed to 23rd of January 2015 earlier. But that's the argument that is available, that you've got 2 dates have been given by an applicant for a restraint order showing closure of accounts on 2 different dates, a year apart.
But so what? I don't mean that in a rude way. But how does that help the respondent when it's so obviously it can't be that one of the dates is right?
Well, that's really the strength of the argument. It's bringing to the court's attention that argument that could be taken by the respondents is the duty of fair presentation. I accept that there was, on the totality of the evidence, an inference that the 2015 date was an error. But I submit it was incumbent on the appellant, as the applicant for a restraint order, to clarify that was an error. That's my third.
Could you help me? Because Lord Reid inquired as to whether there was, what was the non-disclosure? And you said that it was a duty of fair presentation. Does that mean that you accept that there was no failure of the duty to disclose?
No, my lord. I say it.
Why characterise it in a slightly different way then? And if you can, then please inform us as to what the non-disclosure was.
Well, the non-disclosure is really another way of putting the fair presentation point. It is not disclosing that there are two different dates given for the closure of the SunTrust 1 account.
How about the point that the pleadings and documents are rife with errors? Are we supposed to go through every single document in order to find one? Well,
this is why I don't accept Melinda Friend's point that if effectively it's an error, then it can't be material. There can be errors that go to material facts, and there can be errors that go to immaterial facts. The date for the closure of the SunTrust 1 account was clearly a material date, and it is then said by the appellant that that is an error. It is incumbent, in my submission, on the appellant to make clear that that is an error by putting in a short affidavit from Ashley Stirrup and or a letter from the DOJ.
And why is just as a matter of principle, can you help us as to why, if the error is patent on the documents before the judge, why is counsel under a duty of disclosure?
Lord, it is a spectrum, and if it is absolutely beyond any doubt, then I can see an argument why there is no obligation on counsel.
It depends on the circumstances.
And this is why perhaps if the circumstances were different, if the evidence was different, and we had a run of bank statements on the SunTrust 1 account from November 2015 through to the end of January 2016, then, well, I don't think the judge would have been in a position to not notice the erroneous date in the first place. But I do say it is a spectrum, but I say we're on the side here that it is not so compellingly clear or beyond doubt. And just to finish, my fourth overarching submission, we say, although we accept that the board may not want to engage with the underlying merits. And I think I would agree that if the board was with my learned friend on grounds 1 to 5, then it would be appropriate to remit to the Court of Appeal. But if the board was to consider the underlying merits, we say the judge was right to discharge the restraint order. And we go further, we say the judge was right to hold that it ought never to have been granted in the first place. And that's a finding that you see in the first instance judgment. It's paragraph 19, page 2.
The primary case is it should be remitted if the appellants are otherwise right.
It is, my lord.
Yes, I think you and Mr. Casey are ad idem on this, aren't you?
Yes.
Well, if nobody's wanting us to get into abusive process, then I don't see any need for us to get into that.
Or the nexus point.
Yeah.
Well, on the only distinction I draw between the abuse argument and the nexus point is both on their own was sufficient. It wasn't a cumulative thing. Both were sufficient for the judge to discharge the restraint order. And I do say, if I'm right on the nexus point, then it is quite clear that the restraint order should never have been imposed in the first place because the preconditions in section 25 of modified POCA were just not met on the evidence. And
You're still saying that it should be remitted, though, rather than asking us to decide that point, are you?
I appreciate I'm sort of trying to ride two perhaps slightly unruly horses, and I'm trying to perhaps also have my cake and eat it. I think really what we're saying is that the nexus point is a clear point of law that the board can determine for itself, and if I'm right, then it would make no sense to remit to the Court of Appeal. But again, to use my learned friend's expression, perhaps I'm now overreaching. But that's what we say, and that's why we have the analysis in our written case about section 25 and section 26, and whether there was grounds to pierce the corporate rail, given that we're dealing with realisable property here. Now, it's always a risk when you say you're going to make some overarching submissions that you end up addressing effectively all the merits of your points in answer to the board's question. So what I will do is I will expand on those 4 overarching points insofar as I haven't dealt with them in answer to my lord and my lady's questions. And in so doing, I think if I take them in that order, I will also be dealing with grounds 1 to 6 in that order of my learned friend's case as well. So the first point, relief serving no practical or useful purpose. I think my learned friend has taken you through the relevant chronology. You will have noted that there was an injunction granted by the Court of Appeal on the 18th of December 2019. At that point, the funds were in Gomez & Co.'s account, so that restrained any dealing with the funds. At that point, I think we know that the funds sitting in the account were about $1.5 million US worth, because when one looks at the amended notice of appeal, the relief sought in the amended notice of appeal is to restrain 1.5 million odd sitting in the Gomez & Co. account. That's 885 for your note. One then has the Court of Appeal judgment, 27th of May 2021. Just to make this point, it's page 268 of the record. Paragraph 24, which is a paragraph you haven't been taken to in the Court of Appeal judgment, simply records that the appellant knows that after the restraint order was discharged, the funds were withdrawn from the RBC accounts and the account was closed. As we know, the Court of Appeal refused to reinstate or reinstitute the restraint order. My learned friend has then taken you through the June and July 2021 hearings. Just perhaps to make a couple of points that won't have been apparent, you have the transcripts, but I'll just give you the references, if I may. There was a hearing on the 22nd of June 2021. That starts in additional bundle page 2. Essentially, the Court of Appeal confirmed that as far as they were concerned, the funds were no longer restrained and that the appellant would have to make an application. I think the language used is for a stay, but effectively an injunction. There is a discussion about the letter that my learned friend referred to. And the reason there's a discussion about a letter is because the the appellant had written to the bank, I think I'm right in saying, making it clear that as far as they're concerned, there couldn't be any dealings on these accounts. And the Court of Appeal said that they were wrong to do that, and in fact invited them to, I think they say, rescind that letter, or at least clarify the position vis-à-vis the bank. There is then a further hearing on the 1st of July, which...
Just before you go to that,
My lady.
the 22nd of June hearing,
Yes.
on page 13, where the Court of Appeal says, well, if you're successful in your appeal, whoever has dissipated the funds will be responsible for restoring the status quo.
Yes.
Was that Gomez?
I mean, I don't... It's very difficult to tell from what is meant there, because, again, as my learned friend rightly said, the Court of Appeal have made it very clear that there's nothing restraining those funds, and they are effectively, the company is free to do with those funds as it wishes. So it's hard to square what is said there with that.
And have the funds been dissipated?
Well, I have no instructions on, other than the funds being withdrawn from Gomez & Co.'s account just after the 19th of July hearing. I have no instructions as to...
And who, when they were withdrawn from that account, to whom were they paid?
Well, I will confirm that. My understanding is that they were withdrawn because they are the company's funds, so
Yes,
we're talking about the fourth
indeed, yes.
respondent, and they were withdrawn on the instructions of the fourth respondent, so the directors of the fourth respondent.
To whom were they paid?
I'll need to take instructions, my lord, on that.
Presumably your Gomez knows to whom they were paid.
One assumes so, because there would have to be an instruction.
And was that in the Bahamas, to an account in the Bahamas, or do you not know?
Again, my lady, I don't know, other than the fact that they were withdrawn and it was on the instruction of the fourth respondent, the company. I don't know where those funds were paid to.
What's the professional obligation on solicitors in relation to funds that may be tainted?
In the Bahamas, my lord,
Yes.
obviously I don't. Well, I say obviously. I'm afraid I don't know the position. One would assume that they have similar obligations under the money laundering and POCA that you would have here under the SRA. But
And what would be those obligations here?
well, you'd have to ensure that the funds, you know where the funds have come from.
And where they're going?
Well, you would need to obviously have instructions as to where the monies were being paid to. But I can endeavour to find, give a more definitive answer as to solicitors' obligations in the Bahamas, because I'm afraid I don't know the answer. Just,
I'm sorry for asking
No, my lord.
this. Were all the funds paid to the same person, or were some of them retained by Gomez?
by the way, I don't know.
Yes.
So when I take
Yes.
instructions, I will
Yes.
find that out.
They might have been paid for their services out of the funds.
Very possibly, because as we know from, there was an application to release certain monies, and I think $400,000 were released.
Yes.
And I think it was 150,000 was for operational, no, I think it was the other way. I think there were operational expenses of the company, the fourth respondent, and the rest was retained for legal services. I think the parties, though, are working on the basis that the entirety of the funds were withdrawn from Gomez & Co.'s account. But as I say, I'll see if I can clarify. Just again, for a point to note, there's a hearing then in the Court of Appeal the 1st of July, and Mr. Gomez is asked to confirm that the funds remained in the Gomez & Co. account, and he gives that confirmation. That's additional bundle, page 38. And there was then a hearing on the 19th of July, and that is, as my learned friend took you through, effectively there's a withdrawal of an application to stay. We see that in additional bundle, page 83, and then that is recorded in the Court of Appeal's order, which you have got in the electronic bundle. It's page 918. So following that hearing on the 19th of July, the withdrawal of that application, the funds were no longer restrained, and then, as I say, it's common ground that they were paid out. So in my submission, there is no realisable property to restrain, and no basis to reinstate the restraint order. I would accept that Melendez could apply or could vary as part of the relief the restraint order, akin to what was done by the time it got to the Court of Appeal, because effectively the original restraint order obviously sought to restrain the funds in the two RBC accounts. In the Court of Appeal, when it was known that it was in the Gomez account, the relief sought was to restrain the funds in the Gomez account. The appellant is silent on the relief it seeks, so I don't know if that is something that the appellant may wish to do. But that's why we say it is effectively a moot point. The point on ground one, the Baker point, if I can call it that. Again, if I can just ask my lord and my lady to just look at it again, the 19th of July 2021 hearing, so starting in additional bundle 45. So this is the hearing to determine conditional leave. I just want you to look at this just for what is said about this argument. If we perhaps a shorthand call it the Jennings argument.
This is additional bundle 45.
Additional bundle, I think the transcript of that day starts at 45, and it's page 61 that I'd like to take you to.
Thank you.
So you see that Mr. Higgins, top of the page, this is him quoting from the skeleton, as he says, paragraph 14 of our skeleton, thank you. And were those principles submitted to the court for consideration? Justice of Appeal Evans says, and it's accepted by Mr. Higgins, no, they weren't. So you're saying that you wish to appeal on matters which we did not raise before this court and on which we would not have an opportunity to rule? He says yes. And then Justice of Appeal Isaacs at line 21 thought that not to have been raised in this court so the court can make a determination. So when the Lordship's Privy Council come to consider your appeal, should it reach there, that they are provided some helpful guidance as to the approach of this court. Then over the page, Justice of Appeal Evans says, especially as you formulated the ground in saying that this court failed to take those principles, I can understand if the principles were so well known and trite that one will say that the court should have been aware of them. But if these are not well known or novel principles, which they may very well be, then it seems that it is difficult to say that the court failed to take them into consideration. Now, as far as the respondents are aware, and I don't think the appellants say any different, there's no Bahamian authority dealing with Jennings, SFO and A, and the case of Stanford. And that really is, I think, what Justice of Appeal Evans is alluding to in that passage of that of the hearing on the 19th of July. I've referred to Baker, if I can just...
Before you do, but do you not accept that they are so obvious and not novel, that where you've got a public authority in support of criminal proceedings seeking to restrain funds that are said to be tainted by the criminal offence committed in those criminal proceedings, that there is a public interest in restraining those funds? Is that not obvious and plain? It's novel?
I would accept that public interest is a relevant consideration. I think the point I make, though, is that there is no Bahamian authority on that.
Do you need it, is really my point. Do you need Bahamian authority, or is it not just so obvious that it is a factor to take into account?
I think, in my submission, given that there is no Bahamian authority, it would be desirable for the Court of Appeal in the Bahamas to have an opportunity to opine on this point. Which is essentially what they are saying in those 2 pages of the transcript that I've taken you to. So it really goes to the board's exercising its discretion whether it should entertain a point, which is why I come on to Baker and the Queen. And it's in the additional bundle, page 157 is the authority. and it's Lord Diplock's speech at page 171, letter B.
I'm so sorry, I missed the reference.
So it's in the additional bundle, my lady.
Yes.
The relevant quote is 171, page 171,
Thank you very much.
letter B. Where it is said, in any consideration of the binding effect of a decision of a board of the Judicial Committee, it's important to bear in mind that it's not normal practice, that its normal practice is not to allow the parties to raise for the first time in an appeal to the board a point of law which has not been argued in the court from which the appeal is brought. Exceptionally, it allows this practice to be departed from if the new point of law sought to be raised is one which, in the board's view, is incapable of depending on an appreciated matters of evidence or of facts of which judicial notice might be taken, and is also one upon which, in the board's view, they would not derive assistance from learning the opinions of judges of the local courts. Obviously, we say this isn't an evidence case. The evidential landscape would be no different had this point been taken below. This is a pure point of law, and we say, really, for the reasons that the Court of Appeal themselves have said in those 2 pages of the transcript on the 19th of July, it is a point that the Court of Appeal would have wished to consider for themselves. So it is not an exceptional case which would justify a departure from the board's usual practice. If the board's not with me on that, then as to the substance of ground 1, there are it's quite a lot of common ground. 2 main points of common ground. First, it is common ground that there is an obligation on an applicant for a restraint order at an ex parte hearing to put everything which might affect the decision whether or not to grant the order before the court. And although that is common ground, perhaps if I can just ask the board to look at the case of SFO and A. It's judgment of Lord Justice Hughes, as he then was. It's 1333. Case concerned a restraint order following an external request from Iran, but for present purposes, it's what is said at paragraph 6 by Lord Hughes, namely that the court insists on full and complete disclosure by the applicant of everything which might affect the decision whether or not to grant the order. As I say, that's common ground, but I just refer to that passage. And
It's paragraph 46, do you see?
Paragraph 6, page 1335, my Lord.
Thank you.
And a later judgment of Lord Hughes, it's the case of Stanford International Bank, which is at 1377. This case concerned a restraint order made following an external request, but on this occasion from the US. And it's what is said at paragraph 191, which is page 1453, by Lord Hughes, where he says, an application for a restraint order is emphatically not a routine matter of form with the expectation it will be routinely granted. Prosecutor seeking an ex parte order must put on his defence hat and ask himself what, if he were representing the defendant or a third party with a relevant interest, he would be saying to the judge. Obviously, I return to that point later on my submissions on grounds 2 and 4, because we say, leaving aside the issue about the January 2015 date, the appellant plainly, in my submission, didn't say all that could have been said on behalf of the company and Mr. Smith and Mr. Allens at the ex parte hearing. The second point, though, of common ground, related to the first, is it is common ground that public authorities applying ex parte for restraint orders come under the duty of full and frank disclosure that applies generally in ex parte orders in civil cases. And we agree that that is the position in England and Wales, also the position, obviously, in the Bahamas. Now, where we disagree, although as I alluded to earlier, may be really a question of disagreement as to emphasis rather than principle, is the role that the public interest has to play. And I think, having heard Millen and Friend's submissions, it may be that there is very little between us, because what is said in the appellant's written case is that the touchstone is the public interest. Now, in my submission, if what is meant by that is that it is but a relevant factor to consider, then there's nothing between us, because we say public interest is but one factor to consider. We make the point that the public interest does not constitute a distinct and separate test. And that is what is said by Lord Justice Laws at the passage that you were taken to in Jennings. So at paragraph 54 through to 56 that you were invited to read, Lord Justice Laws makes the point it's not a distinct, discrete test. It is a factor to be taken into account. So that is what we say on the principles. Our second point, though, is that the Court of Appeal, as I alluded to earlier, would have clearly had in mind the public interest in making restraint orders. But we say the public interest insufficient, in this case, to tip the balance in favour of reinstating the restraint order, essentially for the reasons that the Court of Appeal give, that we've summarised at paragraph 58 of our written case, which is page 1004. The Court of Appeal placed particular emphasis on three factors. You've been taken through the Court of Appeal's judgment, so just to perhaps headline them. Carelessness and culpability of the appellant, paragraph 40 of the Court of Appeal's judgment. Court of Appeal held that failure to recognise the inconsistency in the evidence was, their words, inexcusable. Materiality of the information.
Which paragraph is that, sorry?
That's paragraph 40, page 272 of the Court of Appeal judgment. Materiality of the information not disclosed. Court of Appeal addressed this at paragraphs 33 and also 40. They effectively say if the date of the closure of the account was not an error, then it went to the root of the appellant's case. So in other words, it wasn't a subsidiary or tangential issue. And what the Court of Appeal attach significant weight to is this third point, which namely the appellant had the opportunity to in their words, cure the non-disclosure, but failed to do so. That's the point they make at paragraph 41. And as I said earlier, whilst I accept there's no reference, I can't point to the Court of Appeal judgment where they expressly refer to the public interest, they would have plainly been aware of the public purpose behind restraint orders, the efficacy of the relevant provisions of amended POCA. But having carried out the analysis that they did, the conclusion that they reached at paragraph 42, where they say it's difficult to see how it could properly come to the conclusion that the restraint order should be reinstituted. To perhaps just put that in the language of Lord Justice Longmore in Jennings or Lady Justice Sharp in the case of A&A, which we've referred to in our case, where they talk about really the touchstone being whether a restraint order was appropriate. What the Court of Appeal is saying there in my submission is that it would not be appropriate to reinstitute a restraint order in these circumstances. As the appellant did, I'll address grounds 2 and 4 together. This is really the was it material, was it an error, and if so, was it material? And to summarise Miller & Friend's argument, it is really that if it's clearly a mistake, then the Court of Appeal ought not to have concluded there'd been a material non-disclosure. And as I submitted earlier, that argument does overlook that there was a duty of fair presentation, and I've made my submissions that there was an argument available to the company and also Mr. Smith and Mr. Allen's that on the face of the evidence relied on by the appellant, the Sun Trust accounts had closed prior to the impugned transfers of money, such that there was no link between the money in the RBC accounts and the fraud on Boeing. And we do say in those circumstances there was a duty to bring that argument to the court's attention and at the very least to draw attention to the 2015 date that was said by the appellant to be an error. And I've taken, my lords and my lady, to what was said by Lord Hughes in the Stanford case. We say that is that duty clearly is engaged. You putting on your respondent's hat. This is a point that should have been brought to the judge's attention. Anyone representing the company and or Mr. Smith and Mr. Allen's should have pointed out that inconsistency between the two dates. And I've made the point already that at no stage were the SunTrust accounts, statements of the SunTrust 1 account before the courts below.
You're focusing, are you, on what should happen before the judge? Are you making these submissions?
Well, my Lord, yes, but also by the time we get to the court, it applies with equal force by the time we get to the Court of Appeal, because the evidence hasn't altered, as it were. There's no correction has been made by the time one gets to the Court of Appeal.
But you accept that the documents Mr. Casey took us to were before the Court
Absolutely.
of Appeal?
Yes.
So it's just SunTrust accounts. We didn't have the run of the SunTrust accounts.
No.
But we had all the other material.
Yes, my lady, although I don't, saying all the other material, it sounds as though there's a sort of wealth of material that documentary material that points to the fact that the accounts must have been opened between November 2015 and January 2016. I say there are statements made in affidavits. There are no bank documents that categorically make that clear, which is why I do keep on coming back to a run of statements. And as I say, I alluded earlier to we did have some statements that were before the court, the RBC statements. So they were served under cover of Stirrup 5 on the 31st of May 2018. So sort of a year after the ex parte application. So we see those. Stirrup 5 starts 772, but the accounts are 789. So these are RBC accounts.
So this was a year after the application for the...
So Stirrup 5 was 31st of May 2018. So it was put in a year, just under a year after the ex parte application.
Thank you.
And even, so these are the only bank statements that were in evidence. They're the RPC bank statements. And I think the most that could be said here is that if one looks at an entry on the 15th of December 2015, which is the sixth...
Sorry, page 789.
Page 789, my lord. Sixth entry shows
The SunTrust?
transfer. That's the reference. SunTrust US check and check number. And that's the only, as it were, on the face of these statements. There's another page over the page at 790 where there's any reference to SunTrust, and obviously that doesn't identify an account. The reason I take you to that is just that these are the only statements that were before the court below. And although further information was provided in Stirrup 3, and also this is Stirrup 5 that we're looking at, in my submission, the court could not have dismissed an argument based on the fact that the SunTrust accounts closed before the relevant transfers. And although there was an inference that the 2015 date was an error, possibly even a strong inference that the 2015 date was an error, that remained uncorrected. And as I've submitted already, I say the onus was on the appellant to correct that.
What was the date of Stirrup 3?
Stirrup 3, my lord, is 14th of March 2018. Sorry, no, that's Mr. Smith's. It's 4th of April 2018. It's 635.
Will you accept if there were transfers as the request in the affidavit Stirrup 1 said, then the account must have been open?
If the transfers are being made from the SunTrust 1 account on the dates that are set out in the affidavit, then obviously you would need a live account to make that transfer. And the point I make about it remaining uncorrected, this is the point that the Court of Appeal they make it in their judgment, but also been taken to the transcript of the 19th of July conditional leave application. Additional bundle, page 74, lines 8 to 14, Court of Appeal saying there, you go back to the person who produced the document, which is a point Lord Stevens made, whether that be, in my submission, Ashley Stirrup as the deponent of the affidavit or someone from the DOJ.
That's Stirrup, sorry, that's additional bundle, page 74, lines...
Lines 8 to 14, my lord.
Thanks.
And just final point on this, by reference to an authority, we've referred, I think, to paragraph 29 of our written case, which is 993. We refer to the case of National Bank Sharjah and Delborg as authority for the proposition that the proper place for relevant facts is in an affidavit rather than the exhibits. Delborg was affirmed in the case of Stanford, which the board has as well. If I can just give you the references, if I may. Paragraph 90, judgment of the Chancellor, Sir Andrew Morritt, at the time, page 1422. Paragraph 90.
Thank you.
Lady Justice Arden, paragraph 113, and Lord Hughes at paragraph 188. And so in summary on these grounds 2 and 4, we say the inconsistency in the evidence as to when the account closed ought to have been brought to the judge's attention at the ex-parte hearing. Court of Appeal entitled to find that the failure to do so was both material non-disclosure and failure to fairly present. And for those reasons, we say it's wrong for the appellant to say, if you can effectively show it's an error, then there can't be a failure to disclose or fairly present. Ground 3, I can take fairly shortly. So the complaint under ground 3 is essentially that the Court of Appeal ought to have either determined the correct date for themselves on the available evidence or made provision for an appropriate factual inquiry to take place to determine the correct date. As already submitted, our position is that the burden was on the appellant to establish the date was an error. And I've explained the way, as the Court of Appeal explained, the way that should have been done. But as to what is said about fresh evidence, the respondent's overarching submission is that the Court of Appeal was entitled to find that it was too late to cure the non-disclosure, which is effectively what they hold. Had the appellant properly read the initial MLAT request, it would have realised the inconsistency and then have sought clarification from the DOJ. You also, though, have the fact that when it is brought to their attention, they still had 7 weeks before the Court of Appeal hearing on the 3rd of May 2021. So, again, they could have sought to clarify in that time. There is also the point that there was discussion before the Court of Appeal hearing as to whether there were any factual points for them to determine. And both parties confirmed that there were no factual issues for the Court of Appeal to resolve. If one has a look at page 488. This is a transcript of the Court of Appeal hearing.
Is this in the main bundle?
It's in the main bundle, my lady, yes. Lines 11 to 15. Justice of Appeal Evans asks the parties for confirmation as to whether the court was being asked to resolve a dispute between the factual matrix of 2 affidavits. And then specifically asked Mr. Serville whether there were areas of contention that this court would only be able to resolve with the assistance of cross-examination. And now at page, 49, this is an exchange on 491, lines 6 to 9. Or whether it would be safe for us, the Court of Appeal, to deal with them as is. And both Mr. Serville and Mr. Gomez, for the 3rd and 4th respondents, were content for the record to reflect that both parties, if we have a look at 491, further down the page, lines 22 to 25.
What was on the argument against you? There is no issue, in fact.
Well,
All we have is an obvious slip in one of the documents.
yes, but I suppose the point is this: if the Court of Appeal is right that it ought to have been resolved by way of further evidence, by way of affidavit or something from the DOJ, then the reason I just bring this to your attention is that it's slightly unfair to then say to the Court of Appeal, well, you should have made provision for a further affidavit to be put in when the Court of Appeal are being told by the parties that there are no factual issues to determine. So effectively, the appellant sort of went all in on its point as to whether or not it needed to put in further evidence. Round 5, my lords, my lady. I mean, the premise of ground 5 is that having set aside the ex parte order joining the company, the Court of Appeal erred by finding that the appellant's appeal against the discharge was doomed to fail or could not be pursued. I submit that's not a proper reading of the Court of Appeal's judgment, and particularly paragraph 42 of the Court of Appeal judgment, which is 272. The Court of Appeal first found that the ex parte joinder order ought to be set aside on the basis of material non-disclosure. The Court of Appeal then goes on in paragraph 42 to hold that the appeal against the discharge of the restraint order, to use their words, was necessarily affected by this malady. Now, the malady referred to in my submission by the Court of Appeal is the material non-disclosure. It's not, as I think the appellants would put it, the absence of the company as a named respondent. So the Court of Appeal is effectively finding that material non-disclosure infects not only the ex parte joinder application, but the ex parte application for the restraint order in the first place. I agree, though, with my learned friend that, in answer to Lord Stephen's question, who should have been respondents to the application for an MLAT restraint order, the account holders, the company ought to have been a named respondent in my submission to the application. But I agree again, and I think we say this in our written case, that the company and Mr. Smith and Mr. Allens as directors were entitled to apply to discharge the restraint order pursuant to section 26(5). So as such, the company was therefore a respondent to the appellant's appeal against the judge's decision on that application. So we agree with the appellant that there was no question of the appeal not being properly constituted if the company was not a named respondent on the appeal. But I say that's not what the Court of Appeal is saying at paragraph 42. They're saying, rightly or wrongly, we say rightly, that the material non-disclosure affects the initial granting of the restraint order.
I was just interested in whether or not there was any rules of court or procedure in the Bahamas.
Not
identified, because there is in England and Wales, but
not that I've been able to find at this time dealing with, as we're calling it, modified POCA.
And how about paragraph 37 then of the Court of Appeal's judgment?
Sorry, about 37.
37, yes. To vacate the joinder order will also have the effect of removing a party whose presence is necessary for the proper determination of the appeal.
Well, I agree that it would appear that the Court of Appeal thought that it was necessary for the company, because the company is affected by the order, to be a party. But that doesn't, as it were, sort of carry the day when you get to paragraph 42. Say what the Court of Appeal is therefore saying is that the reason for not exercising their discretion to reinstate is because you have got material non-disclosure, as they're found, in front of the judge when making the application, ex parte application for the MLAT restraint order.
do we find anywhere the Court of Appeal's reasoning as to why it was necessary to join them as a respondent?
My Lord, yes, is the short answer. You have the, let me find it, you have the judgment of the ex parte application to join, because, and it's fair to say, the appellants effectively agreed that it was appropriate for the company to be joined as a party. Let me see if I can just find the judgment. I think it's in the... Page, I think it's 895, my Lord. So it's a judgment of the Court of Appeal, 10th of December 2020. And you see the paragraph 8, page 902. Mr. Gomez concedes that on the face of the record, the proposed fourth respondent appears to be an SO party. So that's obviously Mr. Gomez for the company, for the respondent. And then para 21, bottom of 904, Mr. Serville submits that the proposed fourth respondent was a named applicant in the constitutional proceedings in the court below and featured inextricably in the evidence, the documents, the considerations and the findings in the MLAT proceedings as well. It's been apparent from the beginning of the appeal before this court intended to challenge that part of the judgment. As such, this issue does not catch the respondents by surprise. And then it's paragraph 22, 23 that you see the Court of Appeal's reasoning. Paragraph 22, second line. However, as I understand it, the appellant concedes that the first and second respondents are not targets. It is the proposed fourth respondent who is said to be a beneficiary of the bank account. My Lord, my Lady, that leaves ground 6. And as I started my submission by saying, we agree that if the board is with the appellant on grounds 1, any of grounds 1 to 5, then it would be appropriate to remit to the Court of Appeal, because the Court of Appeal has not determined the merits. And we would obviously reserve our position as to the arguments we make on sections 25 and 26 to make in the Court of Appeal as to whether, in fact, the preconditions were met on the evidence. The board has those set out in detail in our written case as well. My Lords, my Lady, unless I can be of any further assistance, I've come in under my allotted time as well.
Thank you very much, Mr. Poole. Mr. Casey?
My Lord, my Lady, very briefly in reply. Firstly, just to clarify one point, I'm not sure that I made it clear earlier, but on the appeal as moot question on the chronology, I don't think I need to take you to it, but on the 22nd of June 2021, so at this point we know from what Mr. Gomez said later on the 1st of July, the funds were still in the Monique Gomez & Co. account. There was a hearing before the Court of Appeal on that day. And the Court of Appeal said, for your note, this is additional bundle page 16. We note for the record there's been no formal application for a stay of this court's judgment. That was shortly after the references to the dissipating party being obliged to restore the funds and tracing. So that was on the 22nd of June. And then on the same day, the appellant took out a summons for a further order restraining the funds as held by Monique Gomez & Co., which is at page 280. And then, as you've heard, on the 1st of July, Mr. Gomez confirmed that the funds remained in the account. But the problem was that in the meantime, there was no undertaking or order in place, as it were, requiring the funds to remain in that place. And in the event, the Court of Appeal wasn't with the appellant on the 19th of of July, and for the reasons we've discussed, said you don't need an order from us because you can, or as I had said earlier, but obviously with that reasoning in mind, you don't need an order from us if you don't have a meritorious application for leave to the Privy Council, and you don't need it because you can trace. But the appellant had taken out that summons for an injunction on the 22nd of June, but then wasn't able to react in time after the 19th of July in terms of making an application to the board. My learned friend said, I think on the same topic, that now that the funds have left the Monique Gomez and Co. account, there is no realisable property to restrain and no basis to reinstate the MLAT restraint order. In fact, in my submission, that's wrong. The fact that the monies may not be in the Monique Gomez and Co. account now, but maybe in some other account, or may have been transformed into some other asset, wouldn't make them non-realisable property. I'm conscious the board has not been taken to the provisions of the Act. The statutory framework, I think, is dealt with probably sufficiently in the SFI. But essentially, in a case like this, where it's said that CWI is a holder of realisable property because it has received a gift caught by the Act from the defendant, in such a case, realisable property means any property held by the recipient of the gift. Not only the gift, although obviously the gift will normally be the what's in focus. But if you're the recipient of a tainted gift, then realisable property means any property that you hold. Leaving aside, though, that refinement, the more simple point is that, in fact, if the funds were moved out of the Gomez and Co. account into some other account in the Bahamas and are still there, then they're plainly still realisable property, identifiably as the proceeds of the fraud. On ground one and the arguments about Baker and the Queen, in my submission, what my learned friend was unable to do was to say what might have happened differently in the Court of Appeal in terms of evidence or argument if Jennings had been brought to the attention of the Court of Appeal. In my submission, given the nature of the points made in Jennings, it can't be suggested that there would have been some evidential inquiry that might have been undertaken in the Court of Appeal if Jennings had been brought to that court's attention. And indeed, given what on his fallback position my learned friend accepts, is the obvious relevance and importance of the public interest to the question as to whether or not, in effect, a restraint order should be maintained. It can't be suggested and hasn't been suggested that there would have been some difference of approach, which for some reason might correctly have been taken by the Court of Appeal in the Bahamas due to local factors or local conditions. Can I just say something briefly about the two RBC bank account statements at pages 789 and 790? As my learned friend said, these two statements were before the judge at the hearing of the discharge and variation application, and were therefore before the Court of Appeal, having been exhibited to Stirrup 5. They were not before the judge at the hearing of the ex parte application for the MNAT restraint order. I'll come in a moment to what was. Just to say that when one looks at the two statements at pages 789 and 790, the column headings are slightly hard to read, but the column one in from the right is, I think, deposits. And the column two in from the right is withdrawals. in the deposits column, the barring the 248,750 on page 789, which one sees from a few lines down was later reversed with a recharge of 253. Barring that, all of those deposits tally precisely with the table at paragraph 15 of the MLAT request at page 585. The board will remember that the MLAT request set out the information that Sun Records showed as to the dates of deposits and the checks. And so, although the amounts in each case differ very slightly because there must have been banking charges or exchange rate charges, something of that nature, the 9 deposits, barring that 248,750, all tally exactly with and corroborate, if corroboration was necessary, that information at paragraph 15 of the MLAT request. Now, what was before the judge, in case this is important, what was before the judge on the hearing of the ex parte application for the MLAT restraint order was Stirrup 1, which commences at page 566 and which serves largely to exhibit the MLAT request and the temporary restraining order. And also the information which is contained in Stirrup 2, which starts at page 606.
Because it was given by counsel and then confirmed afterwards.
My lady, yes. Hopefully the board's seen the letter that came in from Charles Russell Speechlys yesterday evening. So it's one of those scenarios where, where counsel gave relevant information and then coupled with an undertaking to put in the affidavit, and that was done. And it's potentially relevant because the information included that an indictment had now been filed in the USA against John Doe, the person claiming to be Jonathan Reid. And that's relevant because, again, under the Act, under the modified POCA, the filing of an indictment in the USA is a relevant event for the institution of proceedings, which in turn engages one of the jurisdictions under Section 25. So, although I don't propose to go through it now, given the course we've taken on ground 6, it's another reason, if one's going to look into the reasons set out in Malone Friend's case, so why he says the ex parte order shouldn't have been made by the judge.
Well, we're not going into that, are we?
No, well, my lord, I don't think so. But I simply make the point in case, as it were, that that happens. Can I deal very briefly with what was said about the outset of the notice of preliminary objections hearing in the Court of Appeal and the reference to no areas of factual contention? Because in fact, in my submission, one sees if one looks a little bit back in the record, that the Court of Appeal there was dealing with a different topic. One of the grounds of the notice of preliminary objections was that the appellant was in contempt for having failed to comply with costs orders, and that on that footing, the appeal should be dismissed without reference to the merits. And we see that, in fact, what the Court of Appeal was asking about in terms of affidavits and factual contention was affidavits which had been put in on that topic. I don't need to take you through the dialogue now, I think, in detail, but for your note, it starts at page 485, line 22.
Sorry,
485, line 22. And runs through to 491, line 14. But we see that, in fact, that whole dialogue about the Court of Appeal was saying, well, are we going to hear cross-examination on these affidavits which go to the question of contempt? Are there contentious issues going to that question, which we need to decide? So that is what in the end the parties agreed that there didn't need to be, and that it was non-compliance with the orders, if there had been, was patent. My Lord, my Lady, unless the board had any further questions for me, those are the points I intended to make in reply.
Mr. Paul?
My Lord, just very quickly on the point in answer to my Lord Stephen's question about the funds, I've just been able to take instructions.
Yes, thank you.
I'm told by those instructing me in the Bahamas that there are the same KYC rules there as there are here. Instructions were to transfer the funds to another law firm in the Bahamas, and the entirety of the funds were transferred minus bank charges. So in other words, the 1.5 million US dollars minus some bank charges was transferred out of Monique Gomez and Co's account to another law firm in the Bahamas.
Thank you. Thank you for that, Mr. Paul. Well, we're most grateful to Council for their assistance. We'll consider the submissions that you've made and decide what advice to tender to His Majesty.